Check, 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 check.
Good morning. I call this legislative hearing to order. I request unanimous consent that the chair is authorized to declare a recess at any time. Hearing no objections, so ordered. I want to welcome everyone to today's Subcommittee on Economic Opportunity hearing, where we're reviewing 18 pieces of legislation within the scope of our jurisdiction. I'm proud to say that the vast majority of these proposals are bipartisan in nature, something I consider a hallmark of this committee, and I think the ranking member would agree. Title 38 GI Bill education benefits are the subject of 9 of the bills we have before us. This includes a draft from Chairman Takano and myself to finally close the 90-10 loophole. Under the current 90-10 rule, Title IV students have additional protections that student veterans are not afforded. This loophole makes veterans a target for low-quality institutions that are unable to attract non-federal sources of funding. These institutions often use deceptive marketing techniques and are financially unstable, placing veterans at risk of losing their invested time, effort, and benefits due to a closure. In our recent hearings on this issue, VA has claimed that they lack the authority to crack down on these predatory institutions. This bill and others we'll consider today not only provide that authority, but a mandate for the VA to act. I look forward to discussing these measures today in our shared interest of protecting student veterans. We're also considering 5 bills dealing with housing and homelessness, issues which are crucial in my district, which I'm eager to address. In fact, we're going to have a field hearing in August in my district on housing our heroes, and I hope everybody comes.
I'll be there.
Excellent. One of the bills is my legislation, the Housing for Women Veterans Act, which would require that at least $20 million each year under the Supportive Services for Veteran Families program go to organizations with a focus on helping women veterans. It also requires the VA to analyze and report to Congress on the areas in which its homelessness programs are shortchanging women. At our hearing last week on the economic well-being of women veterans, we learned about the unique challenges that homeless women veterans face. They are the fastest growing population of homeless individuals, having more than doubled since 2006. Just unacceptable. And this bill will better address their needs. Lastly, we have 2 bills to update the Service Member Civil Relief Act and 2 bills improving small business programs for our nation's veterans. There's no question that this is an ambitious hearing covering many important issues. I appreciate the hard work of every member of this subcommittee and the staff. Thank you to our great staff who have assisted in getting these bills ready for review, and thank you for working in a bipartisan manner to get that done as well. And I'd like to also thank the witnesses that are here today for their testimony and for their expertise. I'm hopeful that our work today will lead to many of these bills being passed into law. With that, I'd like to recognize my friend, the ranking member, Mr. Bilirakis, for 5 minutes for any opening remarks he may wish to make.
Thank you, Mr. Chairman. I appreciate it. And thank you for continuing the bipartisan tradition of this subcommittee by bringing up the 18 bills before us today. I really appreciate it very much. While 18 bills in one hearing is a lot, I do appreciate the efforts to continue this subcommittee's tradition of productivity. And maybe I'll rub off on some of the other committees. While I'm supportive of most of the bills on today's agenda, I'm concerned that several of the draft education bills may have unintended consequences. We have the same goal. We'll get it right. The draft bills that would require a GI Bill eligible school to obtain letters of credit, comply with an expanded 90-10 rule, and comply with program integrity rules needlessly imposes partisan ideas that would limit a veteran's choice on how to use their earned benefit to our bipartisan subcommittee. We can agree or disagree if these changes are necessary, but we should agree that VA is not currently equipped to implement, and I want to hear obviously from the VA, to implement these types of rules that are duplicative in some cases of the rules in place for schools to be approved to receive federal student aid through Title IV. And this is why we have the hearings, to make the bills even better, the drafts even better. I understand the Chairman's desire to improve oversight over all schools, and I appreciate that very much, and I share that desire. But I do believe that my bill on the agenda, the Student Veteran Empowerment Act, is the more balanced approach. Of course I would be. I would feel that way. As I outlined at our hearing on school closures, the 2 main provisions in this bill not only stress oversight over all poor performing schools, before they close, but also provide full restoration of entitlements to students who are affected by a closure. More importantly, my bill will require that an accredited school or program to be eligible for the GI Bill, it must also be eligible to receive federal student aid through Title IV. By using this approach, we can avoid duplication of regulation and utilize the expertise of the Department of Education to implement many of the same rules and regulations being discussed today. I believe my approach gets us to the same place the chairman wants to go, but also keeps partisan ideas out of the GI Bill, and I don't feel he has any partisan ideas. They're not all his bills. But the fate of the 90-10 rule, letters of credit, and program integrity rules belong to the Education and Labor Subcommittee, in my opinion. Before yielding back, I want to express my support for two other draft bills on the agenda today. The first is my draft bill that would eliminate the living stipend disparity between the full-time post-9/11 GI Bill students going to school entirely online versus those going to a traditional brick-and-mortar institution. And I've had roundtables in my district. I've asked veterans up here that come to my office, and they think this is a big issue. So I think it must be addressed. Current law requires that online students only receive half of the national average of living stipend payments. But my bill does need work, and I'm going to talk about that. The landscape of higher education is changing, especially for non-traditional students like student veterans, and the living stipend payments to students should reflect that change. I know that several of our witnesses have made the excellent suggestion to amend this bill to simply increase the payment to the full national average of the BAH payments. This would help ensure that participants don't game the system. Not that veterans will, but in other words, we've got to make sure that they get the proper cost of living increase. But again, we don't want people to game the system by choosing online schools located in parts of the country with high costs of living, such as maybe Manhattan. I appreciate the suggestion and intend to make that change before introducing this bill. The final draft I would like to speak about today would modify when a service member must elect to make payments to be eligible for the Montgomery GI Bill. Current law requires that service members make this decision on whether to enroll into this program and begin paying $100 a month for 12 months within the first 2 weeks of their enrollment. Several of today's witnesses correctly point out that this decision comes in the middle of basic training or boot camp, and many service members are not appropriately educated on pros and cons of enrolling this program again, compared to the post-11 GI Bill. Mr. Chairman, we know that most service members use the post-9/11 GI Bill, and it more than likely is a better choice and does not require any payment by the service member to be eligible. That's key. The draft bill would simply delay the requirement to make this decision by 6 months. I feel that's reasonable. This would mean that when this decision is being made, more service members have completed initial training, completed their MOS training, and are likely serving at their first duty station. I believe this approach will help service members make the right decision. When this bill is introduced, we may also include a provision to prohibit new enrollments in the Montgomery GI Bill beginning the fiscal year 2029. We must never forget the service of Sonny Montgomery. He did an outstanding job for many years in this committee as the chairman. This change would reflect the fact that fewer and fewer student veterans are using this program. It is time to sunset this benefit and have, just one GI program on the books. I look forward to discussing all the bills before us today, and as well as hearing from our distinguished witnesses. With that, I yield back, Mr. Chairman. Sorry for taking so much time.
Not at all. Thank you, Mr. Ranking Member. Appreciate your thoughtful remarks. We have two great panels today. I want to thank each of our witnesses for appearing and look forward to your testimony and learning from your expertise. As you know, you'll have 5 minutes, but your full statement will be added to the record. On our first panel, we're joined by Ms. Charmaine Bogg, Executive Director of the Education Service at the Veterans Benefits Administration. Thank you for being here. She's accompanied by Mr. Jeffrey London, Executive Director of VBA's Loan Guarantee Service. Mr. David Carroll, Executive Director of Mental Health Operations at the Veterans Health Administration. Thank you, sir. And Mr. Sean Clark, National Director of Veterans Justice Programs at VHA. Thank you for being here. Ms. Bogg, you're now recognized to present your statement.
Thank you. Good morning, Mr. Chairman, Ranking Member Belarakis, and other members of the subcommittee. I appreciate the opportunity to be here today to provide the VA's views on pending legislation that would affect VA programs and services. Accompanying me today are Jeffrey London, Director of Loan Guarantee Service, VHA colleagues David Carroll, Director of Mental Health Operations, and Sean Clark, National Director of Veterans Justice Programs. Because of the timing of receipt, we will not be—
Ms. Bogg, could you speak into the microphone? I'm so sorry. I just want to make sure your comments are caught for the record.
Okay.
Thank you.
Is that much better?
Much better.
Awesome. Because of the timing of receipt, we will not be able to provide views on all the bills, but we will provide the remaining views in a follow-up letter to the committee. The proposed 9010 bill would prohibit the approval of a course of education offered by a for-profit educational institution if the school does not receive at least 10% of revenues from sources other than federal funds. As written, we have significant concerns regarding the implementation and administration of the requirements. Based on preliminary research, we identified 133 schools that would be potentially affected by closing the 9010 loophole, which in turn would immediately impact approximately 60,000 students. Also, it is unclear if the intent of this proposal is to replace VA's existing 8515 rule or supplement the 8515 rule. We would be happy to work with the subcommittee to address the department's concerns. The proposed Forever GI Bill Class Evaluation Act, which prohibits VA from making the lump sum payment for tuition and fees prior to 14 days after the start of the term. While VA supports the intent of the proposed legislation, we cannot support this bill due to the potential impact on GI Bill beneficiaries. Although this change could possibly decrease some overpayments and debts owed to VA, we believe such legislation would inadvertently shift the tuition and fee debt to the student, as certain schools would still require payment for the period of enrollment. The proposed Principles of Excellence bill would require disapproval of courses at any educational institution that does not agree to or fail to abide by the principles set forth in Executive Order 13607. While VA supports the intent of this legislation, VA cannot support this bill due to our concerns with the potential impact on degree programs at public IHLs and other programs such as on-the-job training and apprenticeship programs that are currently exempt. Currently, there are more than 6,400 IHLs eligible to participate in the POE. Of those, approximately 4,200, representing approximately 700,000 GI Bill beneficiaries, have signed a POE agreement today. The proposed state approving agency outreach bill would authorize SAAs to perform outreach activities. No additional money would be appropriated to perform these outreach activities. VA supports the intent of the proposed legislation. However, it is not necessary, as the SAAs already have statutory authority to perform outreach activities. For example, authorized outreach activities include job fairs, state military ceremonies, and student veteran-related events. We'd be happy to work with the committee to strengthen our partnership with SAAs and the process by which SAAs approve programs. VA supports H.R. 716 if amended. Each year, the Challenge Survey consistently reveals that many of the top 10 unmet needs among homeless veterans are legal needs. The Legal Services for Homeless Veterans Act would require VA to make grants or enter into a cooperative agreement to eligible entities that provide legal services to homeless veterans or at-risk veterans for homelessness. We note that H.R. 716 and this draft bill both address the same issues, but in a slightly different way. VA prefers H.R. 716 and recommends that the committee advance that bill if it chooses to assist homeless and at-risk veterans. The proposed Economic Hardship Report Act would require VA to support Congress within 1 year of enactment a report of the economic factors that contribute to veteran suicides. We fully support the principles and intended result of this bill. VA already has the authority to provide information to Congress or conduct research studies, so the bill provided would provide no new authority in that regard. While VA suggests several technical amendments to the draft bill that would provide express authority for the Secretary to collect overpayments made in connection with Special Adapted Housing, or SAH grants, VA supports the bill. Mr. Chairman, this concludes my statement. Thank you for the opportunity to present our views on the pending legislation. We'll be pleased to answer any questions you or the members of the committee may have for us.
Thank you, Ms. Bogg. I now recognize myself for 5 minutes to begin the question portion of the hearing. Ms. Bogg, as I mentioned in my opening statement, one of the bills we're considering would close the 90-10 loophole as it relates to GI Bill benefits. This is a big concern in the area that I represent in San Diego, and as I know it is throughout the country. In your testimony, you expressed concern with applying this rule equally to training programs that don't have traditional fee or classroom structures. How would you suggest adjusting the rule to reflect these differences without giving such institutions their own loophole?
We would be happy to talk more about that, but I believe there should be a waiver criteria in there similar to 8515. There's certain schools that they don't meet that requirement, and they're in a specialized area of the nation. They're only offering that program. It's a high-quality program, and we're able to at least grant a waiver. In this proposed legislation right now, there is no waiver authority associated with the 90-10 rule.
Appreciate that. You also expressed concern with disrupting the education of students who are currently enrolled in programs that would be non-compliant. I think you said 133 schools. How would you suggest phasing in the requirements, assuming we were able to move forward with closing the loophole to address that situation?
So there's two avenues we would suggest. One is not an immediate disapproval of those programs, but to provide some type of window of maybe 30 or 60 days. From that particular angle, that would be helpful to be able to notify students of what's coming down the path, or to allow schools to remedy the particular issue at hand. And then the other piece of that is maybe you focus on just new enrollments coming in the door versus current students who are attending that program, so we don't disrupt their programs.
I appreciate that. I think we want to avoid unintended consequences. What I would love to do is take you up on your offer, and we can work, with committee staff and the relevant experts in the field that we have back home in my district and in other parts of the country. We've got to address this issue, and we've got to come to some common ground and get to a place where we don't have those unintended consequences, or we do the best we can to mitigate them. But we've got to move forward, I believe, to close this loophole. Executive Order 13607 that you mentioned established principles of excellence to rein in some of the most abusive practices that target student veterans. I understand that to date, a number of high-quality institutions have not agreed to principles of excellence. And as you noted in your testimony, many public universities do not directly control their tuition charges, so are unable to accurately inform students of these costs years in advance as the principles require. Do you believe that this is the primary reason that high-quality institutions decline to participate in the program, or are there other provisions that you think are impractical?
Mm-hmm. The primary reason is the commitment to the tuition and fee piece. For the public IHLs, they're not in control of that, and they have different boards or state processes that they have to go through in order to get that approval. So we know for a fact that is the #1 reason for schools not signing on to the principles of excellence.
Appreciate that. Well, we have the luxury of being able to have enough time to ask you some more questions, something we don't often have. To any member of the panel, on the VA Economic Hardship Report Act, can anyone discuss the level of insight we're currently at in regards to the ties between economic issues like housing insecurity, food insecurity, or underemployment and poverty on veteran suicide? And as a follow-up, What level of understanding do we need to be at, and are we moving in the right direction with this bill?
Mr. Chairman, I'd be happy to address that question. Thank you. We need as much information as we can get to understand what the circumstances are that lead to death by suicide among veterans in this country. And we are very interested in the principles that are in the Economic Hardship Act. What we know from the research, and we can provide some additional follow-up information about what we are sponsoring in terms of VA, in terms of research. We know that economic factors are often part of a constellation of factors, but they're not the only factors. And as DAV noted in their written testimony, it's important that we not just look at individual factors on a one-off basis, but we need to really look at the whole constellation of factors. DAV provided what I thought was a great example in their written testimony. They noted the fact that there may be economic factors involved in someone's life that could be one of the precipitating factors, but maybe those are caused by untreated mental health conditions or an untreated substance use disorder or a readjustment issue. And I think when we study risk factors for suicide and protective factors, we really need to look at everything at the same time so we can make sure that we're understanding what's going on.
Thank you, Mr. Carroll. Appreciate your answers and your willingness to work with us as we address the issues that you see in these bills. And we'll get it right, and we'll hopefully be able to move forward with consensus. With that, I'd like to recognize the ranking member, Mr. Bilirakis, for 5 minutes.
Thank you very much. Appreciate it, Mr. Chairman. Ms. Bogue, well, I know this is not within your control. When should the subcommittee expect to receive department's views on the remaining bills on today's agenda that impact the VA? I asked, as the subcommittee has not received views on all of the bills that were under consideration at the full committee legislative hearing on June 20th. So if you can give us an idea when we're going to receive those views, I would appreciate that. Thank you.
Thank you for that question. So we're actually working through the process right now. I expect shortly after this hearing, within the next 30 days, you will receive our position on those particular bills that we weren't able to talk about today.
Okay. All right, I'll move on. Question for Ms. Bogue again. Many of the bills on today's agenda seemingly duplicate some of the rules and regulations in place for a school to be eligible to receive federal student aid through Title IV. And I know you touched on this. Do you agree that it would be simpler to just require academic programs to be eligible for the Title IV funds in order to be eligible for the GI Bill?
There is some concerns there with just limiting it to Title IV because we have on-the-job training programs as well as apprenticeship programs that don't fall underneath Title IV that are eligible for the GI Bill program.
Yeah. How about academic programs?
Well, in terms of IHL programs, is that what you're referring to?
Yeah, yeah.
Okay.
Yeah, that's right, yeah.
Okay. Yes, we do think there should be alignment in terms of IHL programs with Title IV, yes.
Okay. Next question for you again. What is your view of the Principles of Excellence Bill, including regulations that are outside of VA's control and could effectively eliminate the GI Bill benefits for unaccredited courses?
I will tell you that was our biggest concern with that bill is the impact to non-college degree and OJT apprenticeship programs. So we really want to, if something like that is passed, to really take a look at how do we exclude those kind of programs from this particular bill. In addition, it just references the principles of excellence. So we think that there's key pieces within the principles of excellence that could be codified, and we should look at that and include that in the bill versus an overall general statement of referencing the executive order.
Okay. Again, I know you brought this up in your testimony, but I want to expand on that. Do you believe that the VA is currently properly equipped or staffed to implement regulations related to the 90-10 rule or a rule requiring that all schools provide letters of credit?
We do express concerns with that in terms of that work will heavily fall into our state approving agencies, and we've had conversations with the state approving agencies about that. And we think that there's some items there that need to be addressed of leveraging synergies at Department of Education to alleviate some of that burden for VA to take on this new effort.
Thank you. I share your concern about the need for the SAAs to focus on enforcement and not outreach. However, In your written statement, you stated that the VA requires SAAs to conduct and report on their outreach activities, but does not reimburse the SAAs for the cost of outreach materials. Why require the SAAs to do something you don't reimburse them to complete?
We actually report on the outreach events they're attending. So if they're going to a job fair, each quarter, for the most part, the SAAs are providing us reports as it relates to travel and other administrative costs. So we ask for them to report on the actual events, not any other items as it relates to marketing materials and things of that nature, because we do not compensate them for that.
Okay. One last question, and I may have a follow-up on here too. Do you know how many students would be impacted by the proposed 90-10 change? I know you may have addressed this, you may have answered this question in your testimony, but if you could repeat it, I'd appreciate it.
In my oral, I did state that we initially identified 133 schools that could be potentially affected by this, which would in turn impact about 60,000 students.
And again, I think you've expressed your view on this, but let's reiterate. Are you concerned that there's no waiver authority for the Secretary to protect student veterans whose school may not immediately meet these new ambiguous standards?
Mm-hmm. We highly encourage that there be a waiver authority. Right now, we have the 85-15 rule, which is similar to 90-10, but instead we count students versus dollars to protect students from certain schools, and there is a waiver criteria in there. So we believe that if something like this is passed, there should be a waiver criteria that's imposed in this as well, so that way we can account for some of those high-quality programs that are doing what they need to do, but they might not meet that 90-10 threshold.
Okay. Well, thank you very much. I appreciate it. I'll yield back, Mr. Chairman.
Thank you, Mr. Ranking Member. I'd now like to recognize Ms. Luria for 5 minutes. No questions from Ms. Luria. How about Mr. Bergman?
Thank you, Mr. Chairman, and you know, always a target of opportunity. I see some uniformed individuals in the doorway, and thank you for. I see one Order of the Arrow. Is that Brotherhood? Okay. Well, you guys look great in uniform. Thanks for being part of Scouting. It'll make you the adults that you're going to be in the future. I just had a chance a couple of months ago to participate in my oldest grandson's Eagle ceremony out in California. So thank you for what you're doing already.
I'll claim them for my state too, Mr. Bergman.
Well, you know, we don't get a chance in these kind of hearings to acknowledge all the good behavior that is done on so many different levels, but it takes leadership at all levels, whether you're talking about veterans. And by the way, my scoutmaster was a Korean War vet. Our scout troop was the only one in our whole area that knew how to do march as a platoon and do close order drill. But anyway, that's a different story. Thanks, Mr. Chairman, for holding the hearing today and for including my bill, H.R. 561, the Protecting Business Opportunities for Veterans Act of 2019. I'm proud to have worked closely with my colleagues, Representative Custer of New Hampshire, Representative Dunn of Florida, and Representative Pappas of New Hampshire on this legislation. I'm glad that we are once again considering it after it passed our full committee in the House of Representatives by voice vote last Congress. H.R. 561 would ensure that veteran-owned small businesses and service-disabled veteran-owned small businesses actually receive the VA contracts set aside for them by the VA Vets First program. As a bit of background, you know, unfortunately, some companies have used improper pass-throughs, meaning that they subcontract out all or substantially all of the work to a large company and nonetheless collect the profit. That's wrong. These improper pass-throughs have long been prohibited by law, but they occur throughout the federal government, and especially in recent years seem to plague the VA, which lacks the tools to detect them and to enforce the rules. And you know, we want to make sure that the VA is armed and ready to promote good behavior, but also to make sure bad behavior is appropriately punished. These practices waste taxpayer dollars. They cut into profits intended for veterans and service-disabled veterans, and sidelines the law-abiding veteran business owners who want to perform the work. You know, on the legislative side, this bill protects veterans and cracks down on bad actors and loopholes by ensuring that every bidder in the Vets First program must certify that they will perform the agreed percentage of work required by the law. Additionally, the VA must refer suspected violators to the Office of the Inspector General for investigation, as well as consider a more effective way to find, stop, and where appropriate, punish the improper pass-throughs. Our message is clear. We do not tolerate those who abuse the system and disadvantage our hardworking veterans. To the panel here, as folks from, the VA, I understand that this legislation may not necessarily be in your particular area of expertise, but have any of you ever come across the issue of improper pass-throughs in your respective careers at the VA? Okay. So, not at all. You're focused in a different area. Well, I wanted to say that it's one of those things, whether you're talking about veterans education and veterans benefits, when you think about when somebody leaves the military and they've earned their GI Bill and all the different things that they have after honorable service, is that it's important, I believe, that the VA look across boundaries. Don't get caught up in the stovepipes to the point where you don't look out and see what's going on, because if someone has used their educational benefits, gotten the degree, gotten the certificate that allows them to go into business, we don't want to have that effort that they have put forth, all that effort at that point. So I would suggest to you it's always good to look outside of our particular silo that we happen to be working in. And I thank you for all you do, and I look forward to the next panel here. But Mr. Chairman, I yield back.
Thank you, Mr. Bergman. I now recognize Mr. Cunningham for 5 minutes.
Thank you, Mr. Chairman, and good morning. I want to thank you all each for taking the time to appear and testify. Ms. Bogue, Mr. London, Mr. Carroll, and Mr. Clark. We appreciate the work you all do for our veterans, and I wanted to tell you how much it means to us. Specifically, I represent the 1st District of South Carolina, from Charleston basically all the way down to Hilton Head. And I'm proud to say we have the around 70,000 veterans in our district, and the highest number of veterans in the entire state of South Carolina. So it's an issue that's near and dear to my heart. And Ms. Bogue, I want to ask you something. That in your written testimony on the draft bill to direct the VA to study the link between economic factors and veteran suicide, you stated that the VA is already supporting research on the risk factors associated with veteran suicide. Can you briefly describe that research?
I'm going to defer to my VAJ colleagues to answer that question.
Okay.
So, yeah, thank you, and thank you, Mr. Cunningham, for your support. And this is such an incredibly important issue for us. So, currently the VA's Office of Research and Development is working with the Henry M. Jackson Foundation on a study to look at a comprehensive set of factors that include psychological and physical health, vocational health or employment, finances and social relationships, and this is a large study that is involving, I believe, over 9,000 individuals in it. And there are some preliminary results. The final results are not available yet, but we'd be happy to make that available to you. Within VA, we have put together some programs to help teach financial literacy skills to veterans. And as I referred to earlier, I think just the general context for this is our preference or our recommendation is to look at multiple risk factors. We know there is never really any one single cause of a death by suicide. It is multifactorial. Financial issues, legal issues, mental health issues, adjustment issues can all be part of the constellation. I think often that leads to issues of loneliness or not feeling that one belongs. So it's really so important from our perspective to look at multiple things together rather than to do one-offs. But this particular study does specifically include the financial issues, and as that moves forward, we'd be happy to provide more information to you.
That'd be helpful. Thank you so much, and thank you again for the services you all provide. I'd yield back to the chair.
Thank you, Mr. Cunningham. I'll now recognize Mr. Banks for 5 minutes.
Thank you, Mr. Chairman. Really appreciate you adding H.R. 2618. My legislation to this agenda as well. I think all of us agree that military spouses shoulder an enormous burden on behalf of our nation. Aside from having to watch their loved ones leave home for deployments, spouses are repeatedly asked to move around our country following the orders that their spouse in the military receives. As a result of these frequent moves, spouses in many career fields are forced to sacrifice their own personal ambitions. However, a portion of this burden can be alleviated with administrative relief, which is the justification for my legislation, the Portable Certification of Spouses Act of 2019, which seeks to do this through two main objectives. First, to improve the portability of occupational licenses from state to state, and secondly, to alleviate the burden military spouses endure when having to re-register a small business in a new state. This is the first of many steps to address these challenges, but a step worthy of bipartisan support on behalf of our military families, which is why I'm very pleased that this piece of legislation is on the agenda for discussion today. Now, I understand that the panelists in the first panel might have little to no jurisdiction over these issues, and I have to head to another committee hearing in a different committee here in a moment. Maybe the second panel might be able to address these issues in their opening comments as well. But I once again want to note my profound appreciation for the bipartisan support of common sense legislation like this, which can make a very real and meaningful impact on military families and military spouses throughout our country. So with that, Mr. Chairman, I yield back.
Thank you, Mr. Banks, and I appreciate that sentiment. And I was going to give a shout out to the Boy Scouts that were here, but it turns out they're all from Mr. Cunningham's district, so they all left with Mr. Cunningham. So there you go. Last but certainly not least, with our first panel, I'd like to give 5 minutes to Ms. Lee.
Thank you, Mr. Chairman. Thank you for including my bill also, and thank all of you for the service you do for our veterans. Before I get started, I also want to thank the American Legion, the Veterans Education Success, Veterans of Foreign War, and Student Veterans of America for the feedback that they provided me on, and the committee on my bill, the GI Bill Evaluation Act, which is really intended to give veterans some breathing room, also to try to stop the practice of predatory institutions which target getting veterans into the seat for day one, and more importantly, focus on shifting our payments to encouraging success rather than filling that seat in the first place. And so I look forward to having some input on some of the comments that I received. Ms. Bogue, the VA says it supports the intent of the legislation, but has concerns with the implementation. Can you expand upon that, please?
Absolutely. So thank you for that question. So our concern is that although it says that we don't pay until after the 14-day window, it does not prevent a school from actually collecting tuition and fee payments from the student itself. When we looked at schools across the nation, several schools have a 100% refund policy within the first couple of days of the semester, or a partial refund policy within the first 10 days of the semester starting. So we were concerned that if you have a 14-day window and then VA is not on the hook for the payment for the student, for the school, then the school will go after the student for the payment. So that was our concern there.
Okay. Well, hopefully we'll address that concern, and hopefully we can get your support after doing so. We're on these concerns. Did you consult with any school certifying officials? Have you gotten their feedback on that?
We did. That's why we know the information we know about the refund policy and the window in which there is some type of refund policy for for students.
Okay, great. My next question is to Mr. Hubbard. Oh, I don't have it. Chief of Staff.
Wrong panel.
Okay, wrong panel. Sorry. I will hold off till the next panel. Thank you. I'm done, and I yield the rest of my time.
Thank you, Ms. Lee. I appreciate questions of all my colleagues and all their hard work on this legislation. And with that, I'd like to call our second panel to join us. Welcome, everybody. Everybody ready? All right, all right. Appearing before us today is Patrick Murray, Deputy Director at the Veterans of Foreign Wars. Always good to see you. Next is John Kamen, Assistant Director of Veterans Employment and Education at the American Legion. Thanks for being here. We also have Colonel Robert Norton, Senior Advisor with Veterans Education Success. Thank you, sir. Next is William Hubbard, Chief of Staff for the Student Veterans of America. Thank you. Also here is Jeremy Villanueva, Associate National Legislative Director for Disabled American Veterans. Good to see you. And finally, Timothy McMahon, Board Member of Career Education Colleges and Universities. Thanks for being here. With that, we'll turn right over to our statements from each of you. And Mr. Murray, I'd like to start with you, and you're recognized to present your opening statement.
Chairman Levin, Ranking Member Bill Rockus, and members of the subcommittee, on behalf of the men and women of the Veterans of Foreign Wars of the United States and its auxiliary, I'd like to thank you for the opportunity to present our views on these important pieces of legislation. The VFW supports the intent of the Student Veteran Empowerment Act and have a suggested addition that could improve upon it. Last Congress, this committee passed historic legislation to improve and expand the GI Bill. One of the VFW's top priorities in the Forever GI Bill was restitution of eligibility for student veterans affected by school closures. Thousands of student veterans were caught off guard by their schools closing due to bad financial management, and this committee authorized restitution of their benefits if their credits would not transfer. While this was incredibly important for those student veterans, it only covered people during a certain period of time. The VFW supports making a permanent fix for all students affected by school closures. We also believe schools facing financial instability should require additional oversight and a backup plan if they do end up closing. This proposal would require additional risk-based investigations by the SAAs to help identify potential vulnerabilities for student veterans. We also believe that in addition to this proposal, schools facing financial instability should be required to offer letters of credit if they reach a certain financial threshold. Institutions deemed financially unstable shall provide letters of credit for Title IV, but not Title 38. The VFW believes there should be parity for student veterans attending institutions at risk of closure. It should not be the sole job of VA and the taxpayers to make whole students who were failed by their institutions. Many of these institutions profited off of taxpayer dollars, then the students are bailed out by more taxpayer dollars. We believe some of the burden should also be placed upon the institution itself. Risk-based assessments in conjunction with letters of credit would be a great step forward in protecting student veterans. The VFW supports the proposed legislation. Excuse me. Sir, I'd like to yield the rest of my time.
No problem. Thank you, Mr. Murray. Mr. Kamen, you're now recognized for 5 minutes.
Thank you, Chairman Levin, Ranking Member Bill Rockus, and distinguished members of the subcommittee. On behalf of National Commander Brett P. Reisted and the nearly 2 million members of the American Legion, we appreciate the opportunity to testify on these important issues. Before addressing the pending legislation, we would like to extend a sincere thank you to the entire House Veterans Affairs Committee, as well as the Veterans Benefits Administration for all the work that went into honoring the 75th anniversary of signing the GI Bill. The American Legion was proud to work with Student Veterans of America to coordinate 4 receptions commemorating every aspect of the bill, from home ownership to student veteran success. It is fitting, then, that we carry on this legacy in these halls today. Now, I'm going to address 9010 and go a little bit off the script here. VA raises some important points, and there are some challenges when it comes to it. I think that where we are operating from as a group and what every other veterans group would offer is that perhaps the Department of Education would not abide by eliminating the 9010 rule for them. They know for Title IV benefits they need protections, and that's their protection. The department has a vested interest in ensuring that for taxpayers and for students alike. We want to see VA fulfill the same function, have the same care for Title 38 benefits, and be interested and engaged. Whether it's fixable through Title 38 or not, it's important that they're at the table to defend these veterans and make sure we can come up with a solution, because right now there is none. Now, in addition to this, a separate issue of benefits parity has long existed that has been a divide between online learning and in-class instruction. And while the post-9/11 GI Bill has undergone monumental improvements to meet our veterans' education demands, it is yet to properly value online learning. While in-person learning is awarded with a basic housing allowance consistent with localized housing rates, online learning is currently set at half the national average. This is despite the education landscape's momentous shift towards more online learning. This is despite the fact that many student veterans with family and job commitments do not have the luxury of time to attend classes in person. The American Legion does not believe these students should be penalized for these family and work obligations. As long as they are meeting their school's requirement for full-time learning, the VA must honor this commitment with a full-time basic allowance for housing, and we enthusiastically support the draft legislation to increase monthly housing stipends. Just as the American Legion believes in institutional accountability of these education benefits, we also believe that student veterans need to be empowered to be the best possible stewards of their GI Bill. The Student Veteran Empowerment Act makes a big step in this direction by offering a common-sense solution, requiring student veterans to submit a monthly verification of their enrollment status for the purpose of accurate benefits delivery. The need for this is traced to a 2015 GAO report that identified $416 million in GI Bill overpayments. That's 1 out of every 4 veteran beneficiaries. While minor steps have been made to lower potential overpayment issues, such as school certifying official training, the American believes that 5 years removed from this GAO report, overpayments are still a serious concern. And they are unacceptable because student veterans are often beholden to school certifying officials to send their enrollment information to VA on time and accurately. A simple misstep on behalf of a certifying official puts a debt collection target on the veteran's back through no fault of their own. So let's simply require students to verify their enrollment every month so VA can have close to a real-time information on student veteran enrollment status, saving certifying official from having to conduct monthly reviews and affording them more time for certificate of eligibility processing. While this may be an inconvenience for student veterans, it is not without precedent. To this day, the Montgomery GI Bill still requires monthly verification through its web automated verification of enrollment. It is no surprise that the Montgomery GI Bill has no comparable issues with overpayments. Outside of education issues, the American Legion strongly supports H.R. 2924, the Housing for Women Veterans Act. Since its inception in 2012, the Supportive Services for Veteran Families program has played an instrumental role in assisting veterans and their families in exiting or avoiding homelessness. From 2012 through 2017, the program assisted over 419,000 homeless and at-risk veterans. H.R. 2924 would reauthorize the SSVF grant program for 3 years and specify a gap analysis program designed to provide assistance to women veterans who are homeless. According to recent studies, 30% of women veterans have children in custody, and among unstably housed veterans, 45% of women have children. It is critical that this population is reached to ensure that these programs are having their intended impact, especially when children are at stake. Finally, I touched on the VA Economic Hardship Report Act. The latest Department of Veterans Affairs National Suicide Data Report found that more than 6,000 veterans have died by suicide every year from 2008 to 2016. 2016, the suicide rate was 5 times greater for veterans than non-veteran adults. The American Legion strives to ensure our nation's veterans receive the support and assistance they deserve. And while we were encouraged by some of what we heard in a recent House hearing on oversight and reform for veteran suicides, the topic of economic factors was noticeably absent, and we believe that this is an important step to ensure it. Thank you for your time, and I look forward to answering any of your questions.
Thanks, Mr. Kamen. Now I'd like to recognize Colonel Norton for 5 minutes.
Thank you, Mr. Chairman, ranking member, members of the subcommittee. It's indeed an honor to be here today and an opportunity to present the views of the Veterans Education Success. I'd also like to say, Mr. Chairman, that it's a distinct honor to be among today's young warriors and veterans here at this panel. It really is a special opportunity for me to be with them. VES is a nonprofit organization that provides free counseling and legal assistance to students using their GI Bill, and we work to advance higher education success for all military-affiliated students. The subcommittee today is undertaking critical, common-sense solutions to stop waste, fraud, and abuse under the GI Bill. In our view, the very integrity of the GI Bill is under attack. Defrauded student veterans have lost their one shot at their hard-earned GI Bill. This unacceptable situation is compounded by the fact that the Department of Veterans Affairs claims to lack statutory authority to act on behalf of the veterans they are sworn to serve. Earlier this year, for example, the Education Department cut off Argosy University for stealing federal student aid funds, but VA officials said they lacked authority to protect GI Bill funds. A few years ago, the Justice Department won a $200 million judgment from a college chain for defrauding millions of students and sent the executives of another college to jail for defrauding the education department. Also, earlier this year, 49 states joined together to recover $500 million from a college that had defrauded tens of thousands of veterans. Veterans indeed are understandably angry when they learn that a college that defrauded them remained approved for the GI Bill, even though other government agencies had cut it off. Taxpayers are outraged when they read news of GI Bill funds continuing to flow to schools sued by the Justice Department or raided by the FBI with a college president behind bars. The VA Inspector General concluded last December that 86% of state-approving agencies, quote, did not adequately oversee the education and training programs, and, quote, VBA could not provide reasonable assurance that post-9/11 GI Bill benefits were paid to eligible schools or that students received quality education and training, end quote. The VA IG estimated, the VA will waste $2.3 billion over the next 5 years in GI Bill funds going to schools that should not be approved for the GI Bill. With this backdrop, VA is grateful the subcommittee today is considering legislation to support better outcomes for our veterans. Of the 9 bills before the subcommittee today, I would like to focus on a few for your consideration. The Student Veterans Empowerment Act requires risk-based oversight of colleges that are sued by the federal government for misleading students. We encourage the subcommittee to consider additional forms of action that should trigger a careful check by state-approving agencies of a school's worthiness to receive the GI Bill, as outlined in our written testimony, such as, for example, when a state agency halts new enrollment, as the Texas Workforce Commission did after finding American Technical College had filed false job placement numbers. We commend you, Mr. Chairman, for the draft Principles of Excellence Bill and Section 3 of the Student Veteran Empowerment Act, both of which would align the VA with the Departments of Defense and Education and giving VA authority to take action against schools that violate the VA Principles of Excellence. We urge the subcommittee to merge the best features of both bills. VES also feels strongly that student veterans should have the same rights as their non-veteran peers. For example, student veterans should be able to recover their hard-earned GI Bill when their school closes. We thank the subcommittee for considering legislation that, for example, in Section 2 of the Student Veterans Empowerment Act would accomplish that purpose. We also thank the chairman for his draft bill to give the VA the same letter of credit authority that the Education Department has long used to protect student veterans using Title IV funds. Our written testimony provides more detail on the draft legislation being considered today. For over 20 years, I've had the honor to testify before this subcommittee on GI Bill-related issues, and on behalf of Veterans Education Success and my fellow veterans, I look forward to your continuing bipartisan commitment to those who have worn our nation's uniform. Thank you, and I look forward to your questions.
Thank you, Colonel. Appreciate your feedback, your support, and your service as well. With that, I'd like to recognize Mr. Hubbard.
Thank you. Chairman Levin, Ranking Member Bilirakis, and members of the committee. Thank you for inviting Student Veterans of America to testify on the topic of pending legislation related to veteran transition and economic opportunity. As a higher education nonprofit focused on the successful transition of veterans into the leaders our country so desperately requires, we appreciate the opportunity to share our perspective. I echo my colleagues at the American Legion related to the commemoration of the 75th anniversary of the GI Bill and thank them for their long-standing leadership. We have submitted for the record a comprehensive written testimony addressing the broad array of proposals up for consideration today. Many of these proposals seek to address the gap that exists between legal authorities over education programs and the divergence of these authorities between the Department of Veterans Affairs and Department of Education. Many of these bills are a step in the right direction to achieve parity between VA and Ed. We humbly offer some additional considerations on each in an effort to make them even more impactful. This generation of veterans consistently demonstrates an increasingly sophisticated approach to higher education. We do, however, always keep a watchful eye for predatory schools and programs who frequently seek to take advantage of VA education benefits such as the GI Bill. Previously, I testified before this body regarding the ongoing practice of near blanket enrollment of new recruits and officer candidates into the Montgomery GI Bill. In response, this committee took swift and thoughtful action to address our concerns, proposing draft legislation to extend the time period under which an election must be made for entitlement for educational assistance under that program. I would like to focus the balance of my time on this issue. The Montgomery GI Bill served our nation's veterans well for many years. However, with the advent of the Chapter 33 post-9/11 GI Bill, the older program is now little more than a superfluous tax on troops. Except for a few niche scenarios, the post-9/11 GI Bill provides more generous resources and better overall value than the Montgomery. Despite this, it lingers on through the automatic enrollment of new service members who are not fully informed of the differences of these education programs. A recent Politico article put a fine point on the issue, noting the clear disparities. I shared, at this point, it's just a vestige of a bygone policy determination. They are paying into it for essentially no reason at all. Why does this matter? Consider that the average paycheck for an E1, a brand new private in the military, is just over $800, and that's before taxes and deductions. Further, these troops are also subject to the new blended retirement system, making financial strains a very real prospect. Of the $160 million collected from new recruits each year, over $140 million goes unused and unrefunded. To put this $140 million into perspective, that amount could fund 10,305 students for a full ride at UC San Diego at the in-state tuition rate, nearly a third of the entire 35,000 student population every single year. Yet, these funds continue to be collected for essentially no reason at all. When presented time to review information on their options, service members quickly discern which benefit is for them. From fiscal year 2014 to 2018, a combined 94% of veterans made the understandable choice to use the post-9/11 GI Bill over the Montgomery GI Bill. For visual comparison, this is approximately what the GI Bill looks like today. Overall, the antiquated program is on track to represent barely 2% of VA education benefits next year, a figure which has steadily declined as the post-9/11 GI Bill, now the Forever GI Bill, rose in popularity due to the much more generous resources afforded to student veterans. Yet due to current policies, new service members are often automatically enrolled in the Montgomery GI Bill unless within a few days of entering initial training, they submit a written request to opt out. And just to add to the confusion, public-facing websites on from the different service branches also make it nearly impossible to get clear information about the nuances of the different options. In one example, one of their website reads, "If you sign up and do not want it, there are no refunds." Another states, "Monies reduced are not taxable and not refundable. Monies reduced cannot be stopped or suspended." We thank the chairman, the ranking member, and the committee members for your time, attention, and devotion to the cause of veterans and higher education, and I look forward to your questions.
Thank you, Mr. Hubbard, and without objection, we'll add the visuals that you took the time to prepare to the record. Thank you for that. With that, I'd like to recognize Mr. Villanueva for 5 minutes.
Chairman Levin, Ranking Member Bill Rackus, and members of the subcommittee. Thank you for inviting DAV to testify at this legislative hearing of the Subcommittee on Economic Opportunity. DAV, a nonprofit veteran service organization comprised of over 1 million wartime service-disabled veterans, is dedicated to a single purpose: empowering veterans to lead high-quality lives with respect and dignity. I'm pleased to provide our views on the legislation before the subcommittee today that directly impacts the service-disabled veteran community. My full written testimony addresses the entirety of the bills on today's agenda, but for brevity's sake, I would like to highlight 4. DAV has a long-standing resolution which supports the investigation, prevention, and monitoring controls over the service-disabled veteran-owned small business, or SDVOSB, programs, and seeks to ensure that fraud is prosecuted and companies that commit fraud are suspended or otherwise held accountable. And also Resolution Number 303, which calls for simplification of the verification process for SDVOSBs and veteran-owned small businesses, or VOSBs. For this reason, DAV supports H.R. 561, Protecting Business Opportunities for Veterans Act of 2019, and H.R. 1615, VA-SBA Act. H.R. 561 would correct a persistent problem in contracting under the Vets First program by directing the VA to work with the Office of the Inspector General to identify and penalize small businesses who take advantage of the program by utilizing pass-through contracts, which occur when a small business wins its contract based on a designated preference and then subcontracts most of the work to a non-similarly situated firm. These pass-through contracts violate the principle and rationale of these programs, which is to benefit the SDVOSB community. In a 2018 report, the GAO found persistent problems in contracting under the Vets First program by small businesses who disregarded these subcontracting limitations. H.R. 1615 would move the VA's verification of SDVOSBs and VOSBs responsibility to the Small Business Administration. The SBA will therefore fully take over the certification process government-wide, and VA's separate verification program will sunset. Currently, SBA certifies small businesses that participate in most federally contracting preference programs. The exception is SDVOSBs that are verified by VA to qualify for VA contracts. GAO noted in its 2012 report on the SDVOSB programs, no action has been taken by agencies to improve fraud prevention controls. Relying almost solely on firms' self-certification, the program continues to lack controls to prevent fraud and abuse. The VA-SBA Act seeks to address this problem by instituting an affirmative certification requirement for SDVOSBs throughout the federal government to be implemented and maintained by the SBA. To accomplish this, the Act transfers responsibility for certification from the VA to the SBA and eliminates the option to self-certify. Finally, this bill guarantees that no self-certified SDVOSB will be excluded from a contracting opportunity if the SBA is slow to process its certification application and preserves the unique VOSB contracting preference in VA. DAV supports H.R. 561 and H.R. 1615, and we look forward to working with this committee to ensure their passage. Mr. Chairman, the collaborative efforts made by the VA and its federal partners to end veteran homelessness have shown significant progress in the decade since the U.S. established the goal to eliminate it. However, there are still challenges. A 2016 point-in-time census showed that 9.2% of the adult homeless population are veterans, and while this is a dramatic decrease since 2009, veterans are still overrepresented. For this reason, we support H.R. 716, the Homeless Veterans Legal Services Act, and the draft bill Legal Services for Homeless Veterans Act. I would like to thank Congressman Panetta and Congresswoman Beatty for introducing these bills that would authorize VA to provide grants or enter into cooperative agreements with community entities to provide legal services to veterans experiencing homelessness and veterans who are at risk for becoming homeless. In its most recent challenge report, male homeless veterans stated that some of the top unmet needs were legal issues to include child support, prevention of eviction or foreclosure, restoration of driver's license, outstanding warrants and fines, and also discharge upgrades. Female homeless veterans identified legal assistance in 3 different areas, including child support, prevention of eviction or foreclosure, and discharge upgrades. These legal issues are often significant barriers in obtaining employment, reuniting families, maintaining or obtaining permanent housing, or seeking benefits or child support to stabilize family income. By addressing these issues, a veteran has a significantly better chance at ending their cycle of homelessness. Mr. Chairman, this concludes my testimony, and I would be happy to answer any questions you or the subcommittee might have.
Thank you, Mr. Villanueva. I'd now like to recognize Mr. McMahon for 5 minutes.
Chairman Levin, ranking member, and members of the subcommittee. My name is Tim McMahon. I'm a U.S. Air Force veteran, proud of that. And I'm here today representing my schools, Triangle Tech, the career education colleges and universities, and Veterans for Career Education. I serve as president of Triangle Tech, a nationally accredited career school with 6 campuses throughout Pennsylvania. We enroll over 200 veterans currently. That's around 20% of our student population. For every student veteran and every student enrolled at our schools, we assign a career advisor, a financial advisor, and an academic advisor to every student throughout their entire enrollment. We try to make sure that every student has the necessary support over the 2-year degree program in order to reach their potential throughout their enrollment, to graduate, and to become employed. All students at Triangle Tech have free repeat privileges. By that I mean, if a student fails a course, we offer them a repeat of that course free of charge. We also provide a free refresher program for our graduates. If our graduates change careers or change direction in a career and need refresher in a technical skill that we've taught them, they're welcome to come back and get that refresher training free. We also offer a guarantee to every employer that hires one of our graduates. By that I mean that if you hire one of my students and they are deficient in any area for which we've trained them, you may send them back to us and we will retrain those students free. I tell you this because much of the rhetoric points a finger at what are known as fraudulent career schools. I've been doing this 46 years. I've trained over 10,000 veterans and placed over 10,000 veterans in job-related training, in jobs related to their training. My veterans and my other students earn an associate in specialized technology degree in just 16 months. They attend school 6.5 hours a day, 5 days a week, and they have a career advisor that connects them with employers upon graduation. I don't consider myself a predatory tax-paying career school. I'm fairly typical of most tax-paying career schools. I also serve on the board of directors of the Career Education College and University, a national association of career colleges and schools consisting of nearly 500 campus locations across the United States. I'm proud to be among the nearly 100 veterans that traveled from across the country to Washington, D.C. just before Memorial Day and helped to found the Veterans for Career Education. We veterans founded VCE to support the right of veterans to use their earned veterans benefits, like the GI Bill, to gain career skills at the college or institution of their choice. In 2 weeks, VCE will begin a Let Vets Choose tour across America. We'll be visiting over 20 career schools in more than 10 states for the purpose of listening to the voices of the veterans enrolled in those schools so that they can tell us what their opinion of those schools are, and so they can tell us how to make their experience better. We look forward to sharing the views of those veterans once we've accomplished that trip, and we'll be happy to forward the results of that back to the committee. In a recent Gallup study, 71% of the veterans and service members that graduated from CQ member schools said they were satisfied with their education, and 76% said their employment is directly related to their degree or their certificate earned at the career school. Our schools remain committed to provide career relevant education to those in and out of uniform. Regarding the draft legislation being discussed today, I'll limit my oral remarks to those bills that may have the greatest impact on student veterans and career schools, especially the veterans that choose our schools year in and year out. First, the draft bill to change the 90-10 rule to include military and veteran education benefits in the 90% side of the equation will certainly do more harm than good to our nation's students' veterans. CQ commissioned research to determine the impact that changing the 90-10 rule for tax-paying career institutions and found that at a minimum, 100 schools currently teaching veterans would close. And in that 100 schools, the estimate is that over 100,000 veterans would lose their opportunity for education that they chose. This may seem to be a proper way to impact school closings, but I would say that the biggest impact on school closings caused by 90-10 would be to cause more of them, unnecessarily. The research also shows that over 400 public and private nonprofit schools would fail if they were subjected to the expanded version of the 90-10 rule. The vast majority of GI Bill beneficiaries attend those schools. As a veteran and an educator, I urge Congress to advance and ensure objective enforcement of the draft Principles of Excellence bill instead of changing 90-10. Future education policy must hold all schools accountable if the true goal is to protect all veterans. It seems, based on the rhetoric here in Washington, some advocates and members of Congress believe that veterans are being aggressively targeted by taxpaying schools, and that by changing the 90-10 rule, the issue will be mitigated. Simply put, that's just not true. It won't happen that way.
Mr. McMahon, I'm sorry, but your time's up. Appreciate your comments.
Thank you.
Thank you all for your comments. With that, I'd like to recognize myself for 5 minutes. Everybody will have an opportunity to address what was discussed. And I'd like to continue to be focused on the 90-10 loophole. And I appreciated the comments and concerns about the VA and some in the for-profit university industry. And look, this is very simple. I hear from folks that are dealing with this loophole. There are far too many of our veterans that we are poaching to take advantage of them in order to get the other 90%. I'm not saying all for-profit universities are bad, far from it. There are plenty of people doing very good things. But to deny that this is an issue, one that we must work together in a bipartisan manner to address, completely dismisses the voices of countless veterans that I have heard, and I've only been at this job for 7 months. I have heard their stories. We've got to fix this issue. Let's roll up our sleeves, let's get to work, and let's get it done. We owe our veterans no less. All due respect to those in the industry, you know we can do better than what we're doing today for our veterans. So with that in mind, I want to get into the text that we're considering in my specific bill to address it. It does not provide the VA with any authority to waive 90-10 requirements for certain institutions in extenuating circumstances. Mr. Kamen, Mr. Murray, Colonel Norton, I'd like to hear from all of you on this. Would you support the addition of waiver authority? If so, how should that be structured to ensure we don't create a new loophole?
Sir, we would support some kind of a waiver in extreme circumstances. Obviously, flexibility is always an important thing. In previous bills, there have been, the Secretary has the ability to waive this clause if such and such might happen, and we would be supportive of that.
Thanks.
Mr. Chairman, quite frankly, we're not really experts when it comes to this type of issue of waiver. We would defer to our for-profit colleagues and say, how can we make this work for you? The idea that there's rhetoric associated with this, that we're anti-for-profit, is simply inconsistent with the efforts that we've tried to do to reach out to them to make it accommodating. The simple fact is there got to be guardrails on Title 38, the same way it is for Title 10. It's not 8515. If 8515 worked, they would have included an HEA when it first passed. They knew there were ways to easily get around that. It needed to be based on 90-10 for payments. So however we can accommodate so that the schools don't immediately close, that it matches the guidelines for industry to reach, we'd be looking forward to that discussion.
Thank you.
Thank you, Mr. Chairman. I think we would be delighted to see language concerning a waiver authority. I would just like to point out that, as you know, DeVry University has on its own, it's a large for-profit institution, has on its own declared that it will follow the 90-10 in terms of its own business model. So this is not something that's an outlier situation. Schools should be able to attract any student that needs to go there, wants to go there, and provide a quality education with outcomes that will enable them to have a successful future. So we'd be pleased to work with the subcommittee and your staff on the waiver language. Thank you.
Thank you. Mr. Hubbard, anything to add?
I appreciate the interest and discussion of this in this hearing, Mr. Chairman. I think it has a place in this committee, in this hearing room, in the fact that the taxpayers who are veterans, who have served, are the folks on the end of this discussion who are affected. So though I think largely it does have a place also within the Department of Education and Title IV funds, we have to understand the audience of this hearing, which is veterans, and they are affected by this in a very negative manner. So I appreciate you addressing that in this committee. In terms of the waiver, I think annual SAA monitoring would be one step that might be considered. Understanding the importance of risk-based reviews, I think if we're going to grant a waiver, also following up on an annual basis to ensure it's not being abused is one manner to potentially make sure it's safeguarded.
Appreciate that. And again, this is not intended to be a condemnation of all for-profit institutions. One of my very dear friends, Marine Corps veteran, runs the legal clinics, including the Veterans Law Clinic, at a for-profit institution, the University of San Diego. And when I ask him what's the #1 reason veterans come to you for help, it is to deal with student loan debt, and specifically a lot of issues pertaining to this 90-10 loophole. He's the one that told me about it many years ago. So we've got to fix it. And again, we want to work with the community to come to consensus about the best way to do it. I want to, in the brief time I have left, shift to the legislation mandating that institutions agree to the principles of excellence. Some of you have addressed that in order to receive GI Bill funding. Colonel Norton and Mr. Hubbard, and I'd ask you to go fairly quickly in the interest of time, do you think that state approving agencies are capable of enforcing these principles of excellence?
Yes, I do, if properly resourced and with the proper training.
I would echo that. I think they have a lot on their plate, but they are definitely capable and have the expertise to do so.
Thank you both. And I am out of time for my 5 minutes anyway, but I'd like to recognize Mr. Bergman, who's filling in for Mr. Bilirakis. It's nice to see you up here, sir.
Thanks, Mr. Chairman. And let's face it, what we're talking about here is doing the right thing for men and women who've served their country, pure and simple. I'm going to tell you from personal experience, because we are all a product of our experiences. During my 4.5 years in command of the Marine Corps Reserve, one of the biggest challenges I had within our service specific was getting our reservists into schools controlled by the Marine Corps. Because, and this is not about the Marine Corps, this is just an example that I believe transcends the philosophy of an educational institution, that it's about them as opposed to potentially being about their students. Is an education an end game, or is it a stepping stone? It's a stepping stone, because of the fact you don't become a student to become a student for life. You become a student to get whatever certificate or degree or training that's going to springboard you into the next step of your career and your working career. So when you think about, in some cases, the inflexibility of educational institutions because it likes its product, we can see the results in our education system across the country that has yielded 18-year-olds who are not ready to take the next step. I know it sounds like I'm preaching here a little bit, but the fact of the matter is, by the way, my daughter is a career elementary teacher and has been so for 20-plus years and works part-time with the University of Illinois to evaluate student teachers going into elementary education. So I get feedback on a daily basis. The education starts early on in all our lives. So the point is, as we look at education systems now for veterans, who are they going to go into an educational system right after they finish their active duty? Or are they going to go out and work for a while? Maybe in some cases even start their own business first. That's why when we talk about, and I'm not going to spend much time on the bill that I talked about earlier, the H.R. 561, that talks about the pass-throughs. You're going to have some veterans who go right into the workforce. They've hatched a business idea with some of their buddies while they've been serving, and they're going to go out and start it right away. Only afterwards will they potentially then go seek some certification, whether it be to change their business or to upgrade their business model because now they've become successful and they need more training. So my concern as what we do as a body here, if we agree that the GI Bill works, how do we make sure it continues to work? Well, the bottom line is, and I'm going to ask you a question now, do you agree that by ensuring that the GI Bill academic programs are Title IV eligible, we would, by ensuring that we would meet the goals of the draft bills that would integrate the 90-10 rule, letters of credit, and program integrity rules into Title 38?
Congressman, I would love to answer that question. I think it's very relevant for this discussion. And as a fellow Marine, I think we both understand the importance that all of our branches place on serving our service members. The point that you made that students come first is without a doubt absolutely true in 100% of the cases with good schools. And so we applaud those. Some of them are represented here today. And I think ultimately we do have to recall that nearly 74% of service members within 7 months of separating from active duty will go to school. You're absolutely right that some don't do that. And so understanding that dichotomy and finding a way to best serve them is something that we're focused on. I think ultimately the future of the workforce is going to be dependent upon the ability to have these degrees, and in some cases advanced degrees, as our society progresses. So we appreciate your comments on that and would look forward to working with you on it.
If I can also add that, General, I really appreciate those remarks and very sagely perspective on the role of education in our country. I think, number one, the GI Bill actually, it does have baked into it more room for innovation than Title IV funds. It's absolutely correct. Both, not just 90-10, but also the fact that we can do OJT programs, apprenticeship programs, credentialing, and I think that we do believe that that could be valuable for us to be on the cutting edge of innovation. That carries with it inherent risks. The Service Members Readjustment Act of 1944 did not, this was before education as we know it, so you could use your money for anything. And when it was done, General Omar Bradley, who had overseen the VA, said, no mas, there's too much corruption here, get rid of it. So the Korean GI Bill came out, and there was much less benefits, and we saw this trickle down of benefits because of these concerns that innovation bred corruption when it comes to how it's used. So we need to be isolated and careful, but also take into account that there are potential for going beyond just the spectrum of Title IV.
I see, Mike. Thank you, and I appreciate. I know I'm over my time, but the bottom line is, when you think about serving in uniform, you have to be flexible, you have to be willing to adapt. And my concern is that an education system that exists for itself is not very adaptable. So thank you very much, Mr. Chairman.
Thank you, Mr. Bergman. Appreciate your thoughtful remarks. I'd like to recognize Ms. Lee for 5 minutes.
Okay, Mr. Hubbard, now I get to talk to you.
I've been ready for you.
Yeah, I know. Just one question. SVA said you support the intent of my legislation, the GI Bill Evaluation Act, and I just, but you had some changes. Could you address the proposed changes you'd make?
Yes, and before I go into that, I also want to thank you for your leadership with the launch of the Veterans Education Caucus. I think a launch of that sort and the attendance that we had was representative of the interest in the issues of veterans in higher education. So thank you again for your leadership on that, and we look forward to working with you on many issues, including the ones that you propose. Is there any specific questions that you had about those? I would love to dive into them in detail.
I don't have any specific. I just wanted you to, for the record, to talk about what, I mean, you can be pretty brief on what changes you'd propose.
Fair enough. So for starters, one of the things that we've seen with regards to the GI Bill is largely when those programs were developed, particularly in 2008, there wasn't necessarily a focus on evaluating the overall program. Much like the Department of Education has rigorous evaluations that they do tied to all of Title IV funds, unfortunately, the GI Bill does not necessarily have that same mindset. And so if you were to ask our friends and colleagues at the VA certain nuances about these programs, they don't necessarily have the capability to dive into those details because they're not necessarily collecting that information. So evaluating these programs is of the utmost importance. If we're not able to evaluate them, then ultimately we're not able to show the return on investment that the American taxpayer has made, and therefore it puts the program in the crosshairs. So to be able to have that level of understanding and capability is ultimately most important for the long term and specifically for future generations.
So, you know, the bill is really intended to focus on the payment and making sure that the VA is not paying for classes that veterans eventually drop out of. And there's sort of a disconnect between the timing and just really setting a standard is really what the intention of the bill is about. I'm all for us evaluating programs and making sure that we're investing in programs that actually lead to economic security for our veterans. So is there anything else in particular with respect to that 14-day window?
Well, over the years, we've seen things like clawbacks. There was, over the last couple of years, some instances of nearly over 200,000 individuals having money taken back from them because the way the program is set up currently, it doesn't afford the ability to assess whether or not they are staying in that program. I think if you look at things like the Montgomery GI Bill, which still to this day affords the opportunity for students to themselves certify, things like that would potentially be worth considering because it makes sure that individuals are not in programs or program changes that don't catch up to them for a long time and then force people to be in a position where they're actually having money taken back from them.
Great, thank you very much. Colonel?
Yeah, Congresswoman, I would just like to add that one suggestion we have regarding overpayments, since the VA pays the tuition directly to the school, we believe the overpayment should be, if there is an authorized recovery payback to the government, that it should be done by the school and not the burden put into the rucksack of the veteran.
Great. Yep, I believe that's the intent. Thank you. And thank you for your support of the Veterans Education Caucus as well. And I yield the remainder of my time. Thanks.
Thank you, Ms. Lee. And if there are no more questions, we can conclude the hearing. I thank our witnesses for their expertise and my colleagues for their interest. All members will have 5 legislative days to revise and extend their remarks and include extraneous material. And without objection, the subcommittee stands adjourned.